Okay, so we're going to reconvene. I know we didn't do a full 15-minute break, but, you know, we're grown-ups and we can handle our business as we need to. Most of the time. Great, so our next speaker is Cynthia Burr. Cynthia has been a board member for the foundation, a legal clinic volunteer for like the entire decade that it has existed, was one of the visionaries behind the founding of the legal clinic in the first place, and is kind of my go-to for most of my family law questions. So, without any further ado, Cynthia's going to talk to you all about adoption.
Thank you. So I'm going to be, can I use this? Testing. Oh. I'm going to be talking about second and third parent adoptions for LGBTQ parents conceiving children via assisted reproduction. It says second and third, but I think this could even include four. I am not aware whether a four parent adoption has been done, but I think it could be because adoptions are so discretionary, and it does say in the statute that people can have more than one parent. It doesn't put a limit on that. So I use second and third in the description of my presentation today, mainly because those are the ones that I've seen and been involved with, and are probably more common to what you'd be seeing if you were to volunteer for the project that QLaw is doing. There are many other types of adoptions that I will not be addressing, including foster to adopt adoptions, private agency adoptions, independent adoptions. Those certainly apply to LGBTQ parents as well, but they involve a much more complicated description, although there are some similarities. Those adoptions also sometimes include some state support in terms of the money, and the focus, I think, for the clinic or the project that's being done is going to be for parents that are conceiving via assisted reproduction. And so I'm going to kind of pick up where Jill and Lee left off in terms of talking about what happens with parents after maybe a lot of the people that you're seeing are already legal parents that you'd be seeing in this project. And I think whether they decide to do an adoption or parentage order, or if they decide to just do the acknowledgement of parentage or rely on the presumption, I leave the decision up to them after giving them all of the information. I'm sort of reluctant to take a definitive position on a recommendation just because as of now, we don't really necessarily know how everything will play out in the EPA, and I figure the more options, the better. And if people want to do everything, I think they could. And it's just an extra tool in their back pocket to be able to have an adoption decree in addition to whatever other legal statuses they may have. With that said, I do want to emphasize that from my perspective, I would agree with our prior presenters that the parentage orders and the ways to establish parentage under the UPA are the way that things should be in terms of recognizing parentage for most queer couples. Going through an adoption can be an awkward process, but we do try to make it as at least awkward as it possibly can for these parties that are often already legal parents under the law. I do know that, for example, in California, adoptions are a much more streamlined process. People actually just pay a small fee. They don't even have to do a home study. That's in part because the legislature in 2015 in California, and often is in California, majority Democrats. So they have been able to have a much more streamlined adoption process that contemplates people that are parents via assisted reproduction, particularly same-sex couples. And in doing so, that option is available to people in other states. But here we still have an adoption process that is much like a step-parent adoption, and that's in part because Jamie Peterson, who passed the legislation, or helped pass the legislation, I should say, with respect to the new UPA, is really, of course, envisioning how things should be with respect to establishing parentage in these situations without necessarily taking into account that there are some people that may decide that they want to do adoptions as well. So rather than focusing on making adoptions more of a streamlined process like they are in California, the focus is more on kind of, how things should be, which means that when I'm going to be going through the process of adoptions, you'll see that it isn't necessarily, the best fit, but it still is something that many queer couples are doing. It's very common for people to come to my office and already know that that's what they want to do, even after I tell them everything about the new UPA and all of that. And there's lots of different reasons for that. So the question is if these parents are already legal parents under the law, as they can be, as Jill described and Lee described in their presentation earlier, why would they even be considering getting an adoption? And, maybe to give you more background, there's a perception by some people and some attorneys that there's a much longer background for adoptions, that they have been around a lot longer for queer couples, and that for this reason, this could help make them be more recognized in situations where people may be likely to discriminate. Whether that's the case or not, we'll see. But what we do know is that the U.S. Supreme Court has affirmed that adoption orders must be recognized in all 50 states. That was the case that Jill was referring to. Alabama was refusing to recognize a Georgia adoption judgment decree, and the case actually went to the Supreme Court, and the Supreme Court says, Alabama, you can't do that. All adoption decrees have to be recognized in all 50 states. So there's a Supreme Court case that talks about a very specific situation involving a same-sex couple where the adoption order from another state was upheld. I think that, some of the reasons why people want to get an adoption are because relying on some of the new ways to establish parentage, those ways are new. They don't have as much of a history, and there's some concern that, people don't want to be the test case for those statutes, especially once you get into things that are a little discretionary, such as whether, it would be detrimental to not have more than two parents, those sorts of things. When it has that level of discretion and there is a discriminatory element out there, I think there is some motivation on some parents' behalf where they want to have that whatever additional protection they can have beyond just establishing parentage through the UPA or through a presumption or even an adjudicated court order that's not an adoption decree. Additionally, adoption decrees are more likely to be recognized in foreign countries, we think, because there are, of course, foreign countries that do not recognize same-sex marriage. There are foreign countries that are reluctant to recognize LGBTQ parents, and it is true that adoption decrees could also not be recognized in those foreign countries, but they have been around a lot longer and they don't rely on same-sex marriage. So if a foreign country doesn't recognize same-sex marriage, they may not recognize anything that stems from that, the presumption of parentage associated with same-sex marriage. and therefore they also may not recognize, because they're a foreign country, court orders confirming parentage, because they don't have the same obligation for full faith and credit that other states in the US may have. I would also point out that I do know that their presumption of parentage, and I don't know whether it's parentage orders per se, but the presumption of parentage, relying on that alone because it is rebuttable, it has been challenged in many states, although from what I know, not successfully. So that is good news, but the fact that it's been challenged at all is not good news, and that has been more recent than adoption challenges. I don't think that there's been very many adoption challenges since the Supreme Court issued its ruling in 2016. There are some other reasons to consider adoption. So when you're talking to people, just present these things. I think, obviously they get to make the decision, but there's some layperson familiarity with adoptions. I think that the idea that it further secures parentage and it's just a belt and suspenders approach could be perfectly valid in the current environment that we're in. And of course, some people have political fears, and it's true, this could affect adoption as well. But of course, having more tools rather than less might be something that some parents that are particularly risk averse may want to have. So why doesn't everyone do an adoption, or why might people not want to do an adoption, besides the fact that they're already legal parents, or they can become legal parents through the UPA in the way that the prior presentation described? Well, of course, some people aren't going to want to do it because it's awkward and inappropriate. Again, these are like step-parent adoptions, and these people are not step-parents. They plan to have the children since the conception of the child. So to have to go through this process, these adoptions, I've done a lot of adoptions, probably over 100 adoptions. And when I first started doing them, these were very happy occasions. People would celebrate doing them, and there'd be a lot of people at the final hearings, and it's almost like a marriage ceremony, celebrating the relationship as well as the adoptions. Now when people do them, they're sort of begrudgingly doing them, like, oh, I guess I should do this just in case. And so they can be a little bit cranky about going through the process, being treated like someone who doesn't already have parentage rights. And that could be a reason why some people just don't want to go through it. And of course, that is also a valid decision to make if that's what they decide is appropriate for them. Adoptions can also be expensive. I think when I do adoptions, they end up costing between $1,500 and a couple $1,000. And the project that QLaw is doing, they're actually going to be able to cover all of those fees, which is amazing. So that is not something that people would need to factor in when they're deciding it for this particular project, but it is something that people factor in when they're thinking about doing it outside of this. It's also very invasive, and I know a lot of parenting groups on Facebook where people sort of share things will often talk about how awful it is that they have to get a background check or do a home study, or have to do medical financial information disclosures for adoptions for children that they're already legal parents for. Well, it is, inappropriate, but that is what our process is, again, because it is what we have here in Washington State. And if you're a resident of Washington, you have to do your adoption here. So our statute requires certain things. I know we'll get to the social worker portion about how that might be made more smooth for people that are reluctant to kind of address those things, but that is part of an adoption, and it's just something you have to do in order to get your adoption decree. Adoption also isn't a quick process, not because it takes a really long time in terms of the attorney work. The attorney work is actually a very small part of the adoption process. But just scheduling with the social worker and scheduling with the final hearing when you're dealing with people with kids, it just, for whatever reason, just ends up taking a long time regarding everyone's availability to kind of make those things happen. So because it's not a quick process, of course, people in this world want everything done yesterday. Some people may opt not to do an adoption. And the fifth reason is it may not be necessary. That's true. It may not be necessary, but people are still doing them just in case. Again, belt and suspenders. So, of course, if you think it's not necessary, then you wouldn't do one. Sometimes when people are sort of struggling with figuring out whether they should do an adoption or not, the way that I would describe it is that adoptions are an awkward fit for securing parentage, but that's why they may have additional value, because while ideally these adoptions would not be necessary for parents that are already legally established under Washington law, the decision to proceed with an adoption considers that discrimination exists, and getting an adoption decree provides one more tool to protect against this discrimination. So all of those things that people have to do that they don't want to do in the adoption could be additional things that help make the adoption decree all the more valuable, because they are proceeding as if they are not legal parents, and to have that additional level of security, you know, in the event that for some reason it's determined that same-sex marriage isn't legal retroactively, I think arguably adoptions would be still good. We don't know, of course. So most of the rest of my presentation is going to be about the nuts and bolts of actually doing an adoption. And I'm going to walk you through the entire process from beginning to end. So by the time I'm done with my presentation, you will know how to do a second or third parent adoption. I will say that the forms that I've included are focused on a second parent adoption, but they can be easily modified for a third parent adoption. And at the end, I'll kind of address some of the ways that they can be, or even a fourth parent adoption. When I do second parent adoptions, I will typically do them joint representation, meaning I'll represent both the adopting parent and the partner of that parent together, and I'll have them sign a joint representation waiver and disclosure. But when I'm doing a third parent adoption, I will often have either the married couple represented by one attorney, and then I would represent the third if there is a married couple. If there's not a married couple, or even if there is, sometimes all three would be represented by different attorneys. And that's just because for that, additional element of the third parent, because there are some, different considerations under the statute, just to kind of make sure that there is no issue that someone's interests aren't getting taken into account in that situation. I think that one of the things that I'll mention later when it comes to third parent adoptions is I feel a little bit in conflict about some of the additional things that I recommend for third parent adoptions, because I almost feel like they, shouldn't be required, but it's almost taking into account that, a commissioner or judge is going to see this, and because they haven't seen as many of them, having some additional things, I think, has been helpful in terms of making sure that third parent adoptions do end up getting successfully completed. So with respect to initiating a case, we'll start with, of course, meeting with the clients and sort of talking about maybe some of the things I just talked about what they want to do. Like, do they want to do a parentage order? Do they want to do an adoption? Do they want to do both? And then depending on if they want to move forward with an adoption, what they would do is fill out an intake form. And the intake form that I put together is actually in your materials. So yeah, they're behind the PowerPoint slides. And if you look at the intake questionnaire, there is information there as if this is a second parent adoption. Of course, that could include additional lines if this was a third or fourth parent adoption. It talks about how long that they've been together, how they did their assisted reproduction. I also ask for people to provide their known donor agreement if they have one, if they have a letter from a cryobank or doctor confirming that they used assisted reproduction, I have them provide that. And this is just all the information that's required in order to draft both the initial petition and UCC-JEA form, as well as the final orders. Does anyone have any questions about that? Okay. And then actually, if you page to the next form, if you're looking at the forms, the next thing in there is the certification of assisted reproduction. This is something that could be signed by the doctor that may have assisted with the assisted reproduction, or it could even be signed by a midwife. It could be signed by a cryobank, just some third party that can confirm the parties used assisted reproduction and did not conceive via sexual intercourse. And I can tell you, it's surprising, but there are people that come to my office that conceived via sexual intercourse that talk about how they had a donor, and I have to give them the bad news that, in fact, they don't have a donor. They have a different situation that they need to deal with. So it is important to get this information, because that's what helps actually proceed with an adoption versus another type of action. And Adoption Services does look for this when we finalize the case. I also get the birth certificate for the child. That's just something that the court ends up wanting to see. So I'll do that all at the beginning, just so that we don't forget before we're finalizing the case. The next thing in there, in the forms, you'll see the petition for adoption. And again, this is a form contemplating a second parent adoption. It's a pretty simple form. When I first started doing these, no one that did adoptions would give me the form. But I was able to get the forms from the court. They have some forms that are very archaic that I then changed to make fit second parent adoptions. So that's what this form is. And then later, of course, I did see some forms that other people use and incorporated some other information. So this is just the form that people have to fill out to initiate the case. You can go into as much detail or not about how the parties conceived, and it just talks about how they're seeking an adoption decree, they're going to appoint a social worker, and then, of course, the spouse or partner would join. There's something interesting here, which is, so a lot of the people that are doing adoptions are married couples. So when I'm doing married couples, they will go through the process, and the social worker report is a post-placement report. If they are unmarried couples, there is something in the statute that says that they're supposed to do a pre-placement report as well, but I have proceeded sort of by analogy that the post-placement report is more appropriate for people that have conceived together or, already are in a relationship from the beginning of the birth of the child. And social workers have either sort of combined the pre and post-placement reports for those cases where the parties are unmarried, or they've just done a post-placement report and it's actually been fine. I've never been questioned on it. So looking at appointing a social worker, maybe we'll talk about that a little bit more in the next presentation, but there are some forms there as well. There are lots of different social workers to appoint through the project. There will be some volunteers, or there may be paid social workers that we'll be using. I don't really know yet. I have 3 social workers that I usually refer to people, and people just call them and try to arrange something. Once the case is filed, I will file the, oh, go ahead.
Yeah, I have a quick question. I'm looking at the petition for adoption, and there's the service members civil relief.
Yeah.
Are there issues we need to be aware of?
That's a really good question, and I can say that in my cases, they've never applied. Oh, I'm sorry. The question is whether we need to be concerned about ICWA and the Service Member Civil Relief Act saying that they don't apply. I think that, so first of all, I've never actually had to deal with issues in second parent adoptions regarding these issues. I have in other types of cases. But I think that there may be some angle, because these are confirmatory adoptions, where it could be argued that even if there was something there, that it just really isn't relevant to this type of case. But I haven't ever had to go there. So I just say that they don't apply, and that hasn't been an issue that's come up. If it does come up in a case of yours, then obviously that's something that we would need to explore and just confirm that that's not going to be an issue. But literally no one has circled that those things have come up. I mean, this isn't a contested case, so I don't know where Service Member Civil Relief Act, I don't know how that would end up coming up. So that's just part of the form. That's almost part of, some of this is about making the court feel comfortable. And these forms are just the way that they look, because we just don't want to mess with things too much. We just want to get an adoption decree. And a lot of this is just kind of checking the boxes required by statute and, making it look like how it's supposed to for any other type of adoption, even though ultimately these are very different type of adoptions, because this is just the type of procedure that we're stuck with in order to get an adoption decree. So I don't know if that answers your question, but that's sort of been my experience, and it just hasn't ever come up as an issue in any of these types of adoptions that I've done. So let's see here. Oh, okay, there's the intake form. We already talked about that. We talked about the certification of assisted reproduction. The petition and UCCGA form. So these are all the things that you'd be drafting after you got the intake form, and then you would actually have to file your case. It would take too long for me to actually go into the e-filing system and show you how to e-file a case, but there is a lot of information online about how to do that. These petitions and the UCCJA form and the motion to appoint social worker, these can all be electronically filed through the King County e-filing system. And additionally, the order appointing social worker can be submitted ex parte via the clerk. And what you would want to do is file the motion, make sure that you attach the CV of the social worker that you're appointing. And then you would also include an order of appointment, which I include as a Word document, submitting it ex parte via the clerk. And both the filing of the original case, that's about $261, and the ex parte via the clerk fee is $31. So when you file the case, you get to a page and you hit ex parte via the clerk, and that's when you do this social worker appointment process. What happens ex parte via the clerk? How many people do e-filing or are familiar with ex parte via the clerk? Okay. Okay, well, some people are. It's a little bit confusing. Whenever I have, interns or assistants working for me, it takes them a while to kind of get the hang of it. But what happens is you submit an order electronically, and it gets taken to the commissioner down on the third floor, or emailed to them. Actually, they can e-sign it, and then it gets sent back to you by the court. So you would get an order that's actually e-signed. There could be occasions in some of these cases where I don't know if you'd actually be doing like an informa pauperis, and maybe you'd be trying to not pay any of the fees because the incomes of the parties may allow you to do that. Maybe you'd be doing it in person then, but for the most part, people just do this all electronically. And it's actually really easy once you kind of get used to the e-filing system. If anyone has any questions about that part of it, it's really easy for me to answer those questions. So if you are volunteering for this project, I'd be happy to answer them for you if it comes up. So here's the motion and order appointing the social worker. There is some of the language in here which I would massage. I think I did this actually on the ones that I printed out that are not in my PowerPoint. But you can actually say, for example, the petitioners have legal custody of the child. On this one, it says the co-petitioner has legal custody of the child on the motion and declaration. A lot of this language, you can make it better for people. Don't feel like you have to stick with the exact wording. You can make it reflect the reality of your situation, and it's not going to impact your ability to finalize an adoption in most cases. So once I get the order of appointment, that's typically when I will actually email to the clients the filed petition with case number, UCCJEA form, motion, and order. Yeah, obviously they've signed it before then, but I will give them conformed copies of everything with the order of appointment, and then I'll say it's time for the social worker to take over. And the social worker, we'll talk about that part a little bit later, but that will typically take like a month or two for that to be completed. But once I hear back from the social worker that the report is done, then I can go ahead and schedule the final hearing in the case. So then we get into actually finalizing the case with the court. The next step would be to review the social worker report and ask the social worker if you see that anything is missing. We'll talk about what will be in a social worker report a little bit later. You can also schedule a hearing, and this is when a very important decision is made as to whether to special set the adoption before a specific judge or do the adoption in ex parte, where you get a random commissioner or just whoever is in ex parte at that time. The great thing about doing ex parte is that you only have to give 14 days notice, and you can do it any day of the week, Monday through Friday. That's not a holiday, at 9 a.m. or 1:30 p.m. So there's a lot of flexibility with scheduling. If you do a special set, you have to work with the judge's schedule and the bailiff to see when the judge is available. And I can tell you that my favorite judges to do this before, unfortunately, end up being busy. And so sometimes it'll be a couple months before we can actually be in front of the judge that I would prefer. And I would just say that the judges that I like to do these before are people that are like my clients in the case, because they are adoptive parents themselves in queer relationships. And I feel like that really adds to make the hearing basically as, you know, smooth as it possibly can go. They'll say things like, we understand, you know, that you're already parents and you're just doing this to further secure your already existing parentage rights. So they're not overly celebratory, but they're positive. And I really like that balance that the special set judges give to these proceedings. Because what can happen in ex parte sometimes is they can be a little bit overly celebratory because they don't quite get that these parties already have parental rights and are already parents. So that can feel awkward. Or they may actually be overly scrutinizing because they don't understand that these parties are overly, there's a lot of discretion involved, right? So the commissioners understanding the situation that the parties are in and why they are doing this can help make the final hearing a good or bad experience. I have had experiences with, well, I've had one specific experience with a commissioner in ex parte where I've had a couple experiences where they would come back and say that there were things in the social worker report that were missing or that they thought should be changed. And I'll talk about that when in Lara's section. But in those situations, I really think it's a misunderstanding about what type of adoption this is. And I've actually sat down with the people at the court that are sort of on the adoption committee and tried to explain this to them. So I think it'll be better, hopefully. But we don't know for sure because, you know, there could be someone that's not there that shows up. And so that's where ex parte, while it's faster, you know, isn't always necessarily the best place to finalize the adoption, although I'm hesitant to say that because there are also really great ex parte commissioners that you could end up getting. Judge Spector, who did our last final adoption hearing for this project last year, actually is an ex parte right now in Seattle. So I tried to do it before her, and I put Judge Spector, but nobody told me, and I showed up and it wasn't her. So I think in ex parte, you just are kind of rolling the dice on what commissioner you end up getting, whereas the special sets you can do before specific judges. I do a lot of these before Judge Helson, and I've also done some before Judge Widlin recently, just because I mainly practice in Seattle, but there's lots of judges that would be great for this, and definitely in Kent as well, that I haven't necessarily done them before. When it comes to preparing the final hearing documents, one of the things that you do after you've decided whether you're going to do a special set or whether you're going to appear in ex parte is do the note for hearing. And I've included in your documents a note for hearing that is what we did for the last project. I think it actually includes Judge Spector's name in it. That was for a special set. You'd want to, of course, change that to fit whatever judge you end up doing it before. I also included a note for ex parte. Those are two different types of ways of scheduling a hearing in Seattle King County Superior Court for this type of final hearing, but those are the forms that you would use to schedule the hearing. And what you're going to be doing is you're going to be e-filing that, but then you're also going to end up sending working papers. So you e-file the note, and you're also going to need to e-file the post-placement report, and then also send the note to Adoption Services with a $15 check because they have a fee to review the file. So what Adoption Services does when they get the note. And when I say send, I don't know if you can email it to adoption services or not. I've been physically delivering it, but they just need to get a copy of it, because then they know that you've noted the hearing and they'll review the file. They'll actually review the file without you noting the hearing if you ask them to do that, if you prefer that. But then what they'll do is they'll actually go through the file to make sure everything's there, so that when you are finalizing the adoption, you know that it's going to be finalized. You're not going to show up with your family and the court's going to be like, no, I'm not going to finalize this adoption. I don't really like you. You know, it's not going to be like that. You'll know most of the time in advance that, you know, everything is fine, and you'll be able to proceed with finalizing the adoption. The adoption services will let you know if there's anything missing, and they'll give you an opportunity to have that knowledge so that you can then fix that and bring that to the court at your final adoption hearing. And sometimes, you know, what it'll be is like, oh, you didn't file the certificate for assisted reproduction. Well, you just need to make one, file it, and bring it to the hearing, and you're fine. Along with this, I also do prepare the decree and findings, and at the same time that I'm e-filing the note and the post-placement report and sending the note to adoption services, I also will send working papers to the court. And I've noticed that for ex parte, they really want those working papers 14 days in advance, just like they want the note filed 14 days in advance. But the court, when you're doing a special set, sometimes they're a little bit more flexible. But you'll want to just try to get them to wherever you're having the hearing heard as soon as possible. So when you do send the working papers, you're going to send the proposed orders, the decree and findings. Those are also in your materials. The most important thing that you get out of an adoption is the adoption decree. And so it's important that that has all the language that people want in it. You may want to change it to fit, you know, your particular type of case. I'm very careful to include language in there that says that, you know, this person is a legal parent in all ways as if they themselves gave birth to the child, which is sort of covers everything. And just like ultimate, secure, their parent, no question language in the decree. So once adoption services does their checklist, you will appear at the final hearing and you bring a script. And then let me just go through. So I have some slides here that are some things that I talked about. The social worker report, commonly missed items. We talked about that. Talked about considerations regarding the final hearing. One thing I do want to mention about the final hearings is that they are all private hearings, and these are sealed files, which is kind of nice because then you don't ever have, you know, random other people in the courtroom, and people can know that, you know, they're not going to be in line for too long if they're doing ex parte, because adoptions go first. So some of these I've already talked about, noting the hearing, sending it to adoption services. Oh, here are the notes. This was the one I was talking about. That's a special set. You just fill in the information according to the hearing that you're doing, the date and time. You have to fill in the case number, the caption, all of that. Here are the decree and findings. Here's a list of all the working papers that you'll send. And you can deliver these working papers electronically if you would like. And now we're at the point where Adoption Services does their checklist. I'll send you a nice email that they have everything, although they will note what is missing. Here, I actually got a copy of their checklist, which is in your materials as well. Okay, so we're at the final hearing, and at the final hearing, the clients get sworn in, and they are asked some questions. Sometimes the judge will ask, like, do you want me to ask the questions, or are you going to ask the questions? But they are the questions that are just required for all adoptions. And as far as presentation at the final hearing, I would just kind of a comment that, you know, these hearings can feel kind of casual because there's no one else there, and, you know, the parties are usually, you know, in a pretty good mood because this is a proactive thing that they're doing. But it is good to kind of respect the formality of the proceedings. You know, dress well, be prepared, probably goes without saying. But this is a serious thing, so, you know, you don't want to like laugh too much or that kind of thing. So it is kind of a formal presentation. At the end, some clients do want to take pictures, and I think we took a picture last time we did this project with all of the families. Some people just want to get it done because they're just kind of doing this to get that extra further security, and they're kind of annoyed that they have to do it. That's fine too. If the clients do want to take pictures, you just kind of ask them that in advance, and you can give the judge a heads up that, you know, that's something that they'll want to do. Judges love to do adoptions, even these adoptions still, because they very rarely get people in their court that are doing something that is a nice thing, and that they very rarely have children in their court. So they often are more than happy to be doing these. They are also elected positions. So I think they appreciate, you know, the opportunity to be, you know, doing something that everyone's happy about that they're doing. Here are the questions, the formal testimony that is taken during the finalization hearing. There are some questions that are asked to the birth parents, who's also the co-petitioner for the adoption. This is the formal testimony that I've been doing in these cases since 2006, and I haven't really changed it. And I don't know why this is the formal testimony that we do. But again, I don't really question these things too much. I just know that judges expect for this to happen, so I do it. And as long as we get our adoption decree, I think everyone is happy. So you can see, you know, some of these questions are kind of, you know, odd for these people. Like, do you understand that it creates a permanent legal relationship to the child? Well, sometimes people are like, well, I already have a permanent legal relationship with the child. But yeah, I understand this is a, you know, good thing to get to. Definitely, you know, sometimes people will make comments about how, you know, they're glad that there are people that, you know, like to be proactive and risk averse, and, you know, glad that they're doing this. And most people these days don't really add a lot when you ask, is there anything you'd like to add? But there are some people that will make some comments. Sometimes the judge, if there's a lot of people in the room and the judge can tell that the parties want it to be kind of a celebratory event, they will actually, you know, be a little bit more ceremonial about it. They'll kind of make it like, you know, isn't it good that you're doing this? And, you know, kind of make it a celebration of the relationship as well. And it just depends on what people want. And, you know, the judges sort of take the temperature of the room and proceed accordingly, or, you know, do as you might sort of clue them in. I've actually done this with parties that are separated, or are in the process of a divorce, and I just give the judge a heads up that they're just doing this to, have this additional further legal security for the non-biological parent, and the judge can sort of, know to not be overly celebratory about their relationship then. But they can be done even when parties are separated or divorcing. So this is a picture this was actually prior to these being more sort of confirmatory adoptions, I think. But this was a final hearing I did with Judge Helson, and as you can see, this particular family brought a lot of other family members to the adoption hearing. After the adoption hearing, you'll want to go to the clerk's office, or actually sometimes while they're taking the picture, if there is a picture, you can run up to the 6th floor to get the certified copies and then just bring them back. Because these cases are sealed, it's a pain to get the certified copies later. So you want to make sure to get them when you turn them into the clerk's office after the hearing. And I usually get 3 certified copies. And then I'll let the people keep those, and then 1 regular copy of the findings. Sometimes I'll keep my own copies of the documents just for my own records, not sometimes, always, just to have them just in case the parties reach out to me later and, want to get a copy. That's definitely happened at least 3 or 4 times. There's a cost, $5 for the first page and $1 for each additional page. King County is making some money off of this, but they're also giving us money for this project. So, and then of course clients get the copies as well. And I will scan a copy to the client so they have a scanned copy. Okay, so let's talk about some other situations where people might want to adopt. For surrogacy, yeah, people can get court orders. I've had noticed when people do surrogacies, for whatever reason, they're less likely to do adoptions in those cases. And I guess I don't really know why that is, maybe because they can get the pre-birth order and, I don't know, they just feel like they're not as concerned. But the same considerations technically apply for cases where there's surrogacy involved, because the same concerns of discrimination exist if they're an LGBTQ couple, or a 3 or 4 parent situation. There are cases where the state, for example, if there was a surrogate in Idaho, I've noticed that they do need to do an adoption here in order to change the birth certificate in Idaho. Like, they specifically want an adoption and not a parentage order for some reason. I don't think that should be the case, but it hasn't really been challenged or fixed yet. But that's an occasion when people doing surrogacy, often will reach out to me for an adoption. Surrogacy, the law is really different in Idaho. So that this is, I think they actually do have to go through some sort of process to kind of undo the birth parents' legal rights and everything like that there, that sort of cause an adoption decree to be something that's just required by their particular laws there. We're not going to be having a lot of surrogacy cases, I think, in this particular project, so I'm not spending a lot of time on this, but I just wanted to point out that this is still a situation where a second parent adoption or third parent adoption could be needed. Okay, so wrapping up here, one of the things I noticed when I was going through the new Uniform Parentage Act is that an acknowledgement of parentage won't work if there's another presumed parent or acknowledged parent other than the birth parent. And so I know that You can't necessarily establish parentage through an acknowledgement of parentage as a third or fourth parent. I do think that there are ways you can do that via de facto and via this other RCW 26.26a.460 that talks about that a court may adjudicate a child to have more than two parents if the failure to do so would be detrimental to the child. These are both very discretionary, vague standards that we don't really know what a court is necessarily looking for on some of these. Yet, if you read the rest of this, I'm actually not really, I'm happy that they acknowledge that there can be more than two parents, but when it talks about what's required, I just think it leaves a lot of discretion with the judge or judicial officer that would be adjudicating this, which makes me uncomfortable because I know even in our states, even if our courts right now, even in Seattle, I believe that there are people that would possibly not want to do this. And so that's why I think that there may be some issues for people that are trying to rely on getting a parentage order for a third or fourth parent, just because of the fact that judges and commissioners are human and may have differing opinions as to what would be detrimental to the child. I have noticed that when there are three-parent situations, it does seem like most of them are going through an adoption. I think that because this is so new, from my perspective, out of all of the situations, that would be a situation where I think adoption, should really be considered, because again, this is all very new and we don't know how all this is going to play out yet. With third parent adoptions or multi-parent adoptions, you can use the same forms. I didn't actually provide you with the forms for third parent adoptions, but they're not that much different than what I gave you. You just change them to make them fit 3 parents or more, if that's what you're doing. One thing I would note is if you're doing a third or fourth parent adoption, you would want to be super careful about social worker and judge selection, because there's so much discretion with the social worker and the judge that you want these people to be people that are going to get the situation for these parties. And I can tell you not all of them do. So this is probably the most important part about, doing these types of adoptions. Some social workers or, other attorneys that have been involved in cases or have been doing third parent adoptions want to kind of do these extra things, which, again, I'm sort of on the fence about it, but, because there are 3 parents, maybe having some sort of parenting agreement about what happens if you all break up would be something that would be good to have from their perspective. So they'll ask for that and want to include that with the social worker report, or they'll want the attorney will want to see them do that, or they think a judge might want to see that. Sometimes there's been recommendations that the parties go to counseling together and make sure this is something that they want to do. I don't necessarily think that should be the case, but it's just about kind of essentially you're going above and beyond, and these people are well-intentioned because they want to make these parties, because it's unconventional still, seem like better parents than any other parents that currently exist. And so then they just really can't be questioned at all because they're so amazing and they've jumped through all these extra hoops that, to the extent that you're going to try to bring in some discretion about oh, I'm not comfortable about 3 parents. Well, once you see this, you won't have those questions. And I think that's where that really comes from, to have that additional desire for more documentation in the file, just sort of addressing how great they all are and how they have a plan if they separate and all of that. I would note that that's also true of parties that are separating and proceeding with an adoption. Sometimes people want to see that they have a plan in place, of course, for what's happening when they are no longer together in terms of residential schedule. Again, in these cases, it's just about that like abundance of caution, because it, is a little less common for the, it's more common for the parties to have their own attorney. Some people would even say for second parent adoptions that the parties should have their own attorney, but, I think it's more efficient if they don't. But in third parent adoptions, it's much more common for the married couple to be represented and the third parent to be represented, or for all three to be represented by different attorneys. That's all I have. Does anyone have any questions?
Yep. Thanks, Cynthia. So before we go on to the next presentation, I just wanted to make a couple of notes. First of all, how many of you are here and when you registered clicked saying you wanted to work with a Family Matters client family? Raise your hand. Okay. Now, how many of you are like, oh crap, forms? Oh crap, how am I going to remember all of this when I'm actually sitting with a family? And like, oh, how am I going to like figure out how to work out all the hearings and stuff like that? Okay, don't stress. What we'll talk about at the end of the day is, first of all, we'll have all of the forms for you, ready for you to just plug in information when you sit down with the client family, so that you have everything that you need and it's ready to go. And we will also have support and mentorship-oriented attorneys, some of our speakers, folks who have done this a bunch of times, who are available and on call to be able to ask questions to. I know I used to practice family law before I became the ED of QLaw, and I never did anything right the first time I did it. Never. And it's okay. Me and my therapist talk about it a lot. And I always talked to other people about what I was doing and got clarification. So if you're freaking out, don't freak out. It's going to be okay.